So I want to keep us all on schedule here. I appreciate that everybody's time is valuable. So our next session is the regulation reality in 2018, specifically the latest on DBE, MBE, overtime, and prevailing wage issues. Our panelists are Sarah Cox, who's a member of our construction and design practice here at Dorsey out of our Seattle office, and Rebecca Bernhard, a member of our labor and employment group. Take it away, ladies.
Okay, good morning. I guess it's still morning, right? As Jocelyn just noted, I'm Sarah Cox, and this is Rebecca Bernhard, and we are both lawyers here at Dorsey. A little background about us. Come on. The laser works. Let's see. Oh, you know what? I know what it is. Excuse me for a second.
I'm so glad she knows what it is.
All right, let's see here.
This is a millennial in action.
Yeah, exactly. I am grateful.
Well, let's see if I can squeeze it in. There we go. Yeah, okay. All right, sorry about that.
No, that's okay.
So, Rebecca, do you want to?
Sure. As Jocelyn already said, I'm a partner here in Minneapolis in our labor and employment group, although I'm also licensed in Utah and practice out of the Utah office as well. I have a non-litigation labor and employment practice. I have a traditional labor practice, so I work with our clients in managing their labor relations issues and negotiating union contracts and things like that. And then I also help comply with the myriad regulatory scheme, especially things like the prevailing wage schemes that Sarah and I will talk about, affirmative action plans, and other federal contractor requirements, on top of helping everybody with the usual bread and butter of family medical leave, anti-discrimination, and those kinds of things.
And I'm Sarah Cox. As Jocelyn noted, I'm an associate in the Seattle office, and I'm in our trial group and our construction group. And so I practice primarily construction litigation. I do a little bit of AIA contract drafting and negotiation for contractors, engineers, and architects primarily. I also do a fair amount of lien practice, lien perfection, and if it came down to it, foreclosure. And a fair amount of federal contract negotiation and resolution. So just to give you a little bit of an overview of our presentation, we're going to be focusing on federal regulations that affect the construction industry. So we're starting with DBE, MBE, the qualifications in that regulatory scheme. Then we'll be moving on to overtime, discussing the background of the relevant laws, the Obama administration's attempt to change the rules and regulations surrounding overtime, and particularly surrounding overtime qualification, litigation about those new rules and how that might impact your overall practice in overtime. Then we'll move on to prevailing wages, focusing primarily on the Davis-Bacon related acts, but some other acts and regulations touching DBRA. Then we're going to discuss a few regulatory current events, primarily how the Trump administration's regulation attitude differs from the Obama administration regulations, and how that might affect your business. And finally, we'll leave a little room for questions. I should also mention that we hope this to be interactive, so please feel free to ask questions as we go. So starting out, I'm going to discuss DBE and MBE qualifications. I imagine that many of you have come across this in your businesses, but I want to give you a little bit of an overview of how that operates from a federal and local perspective. So MBE, these kinds of laws operate under a variety of different terms and acronyms, really. There's MBE, which means minority business enterprise, DBE, disadvantaged business enterprise, and occasionally you'll also see WBE, which means women-owned business enterprise or women-led business enterprise, just depending. In Minnesota, It's referred to as the Disadvantaged Business Enterprise Program, so that would be DBE. The Code of Federal Regulations that applies to this is 26 CFR 26. You don't need to really, hopefully, refer to that. But essentially what these laws do is they set up programs to ensure that women and minority-owned businesses have an opportunity to participate in contracts, bidding that is financed by the U.S. Department of Transportation. It applies only to transportation-related contracts that include any amount of federal funds. And it creates annual statewide goals for DBE performance on federally funded contracts. In Minnesota, it is administered by the Minnesota Department of Transportation Office of Civil Rights. And the current goal is that 11.7% of the sum of federally funded contracts to be performed and 7.13% of the sum of all Federal Transportation Administration funded contracts to be performed will be performed by DBEs for the fiscal years 2016 to 2018. So, and when I say goal, that really is more of a requirement, and it sets it up for 2016 to 2018, and then it's revisited every few years. So what are the certification requirements? A DBE can be a women, minority, disabled, or veteran-owned business. So obviously, it's a broad definition of the type of business that can qualify. It must be owned, capitalized, operated, and controlled by a member or members of one of these identified groups. And it's directly under the jurisdiction of the United States Department of Transportation. These groups, these businesses, have to be owned and controlled by one or more socially or economically disadvantaged persons, and that's defined in the Code of Federal Regulations. The businesses must show a minimum of 51% ownership, control, or expertise of one of these individuals listed above, control of daily management and operations of one of the types of individuals listed above, and all applicants, so each owner within that business has to complete a statement of disadvantage and personal financial statement affirming that they're members of the disadvantaged group. And they also have to describe their personal net worth, and they can exclude their primary resident and that sort of thing from this type of statement. The business size is measured in usually one of two ways. It can be the average gross receipts for the 3 previous years, or by the number of employees. And then that is assessed, and then 51% of that business size in the ownership of the business must be one of these, an individual or individuals from one of these groups. So that's just an overtime of the DBE, MBE, or an overview of the DBE, MBE laws, and nothing much has changed recently, but these laws and rules are changing all the time, and they're just something that you want to be aware of in your practice.
Yes.
So the DBE and MBE programs, the way they're set up now, once you get into that program, are you in it forever?
So long as you maintain that foundational criteria, so you couldn't suddenly change your ownership composition, if that's the criteria that got you into it.
And there
And you do
are...
have to register, right?
Yeah, you do have to register, you have to fill out that statement, and there are reporting mechanisms if somebody's suspected, and it happens actually quite frequently that another contractor will report somebody who they don't think is complying. For example, they've lost an RFP to an organization that claims to be DBE, MBE, WBE, and so they'll do a bid protest and challenge the eligibility and the certification requirements. Okay, any other questions? Okay, so moving on to overtime.
So there was a whole lot of motion under the prior administration on overtime, and we will go through that briefly and then try to catch you up. But hopefully everybody here knows that there is a federal law called the Fair Labor Standards Act, and that sets up an exempt, non-exempt scheme, and it's a little backwards because non-exempt exempt means you get overtime, and exempt means you don't get overtime. And it's sort of always strange to have the negative getting the benefit. But the gist of it basically is that unless you can meet one of the criteria for an exemption, you must be paid time and a half, which is the overtime rate, for any hours worked over 40 in a work week, and you must define the work week, and then it needs to be consistent. And many states have their own version of that. For example, California has a daily overtime scheme as well. Minnesota has an overtime rule, but it's 48 hours. So if you were not covered by the federal law, which is pretty rare, you would be able to not pay your employees here in Minnesota until they worked 49 hours or 48 hours and 0.1. So go ahead. So there is two parts of the test to be exempt, and most people focus on the duties, and the last time there was actual real change in the law was in 2004, I think, and they changed the duties tests, and they kind of created this new set of mostly white-collar tests, although they did tweak a few of the other exemptions as well. But the focus in 2004 was changing the duties for the white-collar tests. And they didn't adjust the salary test at that point. And so basically you must make at least 450, sorry, I'm kind of going through this. You must make at least $455 a week, and that's the salary test, and then you must meet the duties in the specific test. And so that's important because the salary test is, although there's the numeric threshold, which I just mentioned, there's also a method test component to the salary test. And that means that you really do make $455 a week at least, regardless of how many hours you work that week. So you can't vary the amount based on the number of hours that an exempt person works, the theory being they're supposed to accomplish larger responsibilities, and so their rate shouldn't be fluctuating with the amount of time. That's what it truly means to be a salary. There are permissible reasons to deduct. There's about 7 of them. So if you're meeting one of those 7 exceptions, you can vary the pay. But in general, as long as someone works 1 hour in a week, they need to make at least $455 a week, which comes out to $23,660 a year. So the first 3 bullets are the main white-collar tests, and computer employees, that's under the federal, was added, as well as the highly compensated in the 2004 amendments, and that's very exciting for folks who have operations outside of Minnesota and all over the country. In Minnesota, it's not clear that we recognize the computer employee exemption, and it's not clear we recognize the highly compensated exemption. So you just need to be careful when you've got only operations in Minnesota. But again, you got 8 hours of slack there, as I mentioned before. And so each of those categories has its own duties, and we're not really going to go into that because, next slide, the real kind of update for you on this topic is that, as probably most of you know, former President Obama tried to do a change to the salary level in the overtime regulations. Then Secretary of Labor Tom Perez issued a new rule on July 6, 2015, and it was set to take effect on December 1st, 2016. And essentially, it targeted the salary level, so it had an immediate raise, and then there was some language to tie it to cost of living and other salary indexes. And so it was going to basically raise the threshold to $913 a week, or $47,476 a year. It also changed that highly comp exemption that we mentioned to $134,000. And then it set a mechanism to update that salary level every 3 years. It also gave a teeny tiny nod to employers and said, if you've got non-discretionary bonuses and incentive comp, and that gets you up, and so they're relatively set type bonuses, you can account for up to 10% of that to meet that $47,000 or $134,000 threshold. But, as probably most of you know, there was litigation, and there was a lot of folks who protested that. I don't think probably any of them were in New York City, because they were already paying way over that anyway, but that was a big jump to go from 23,000 to 47,000 for many small employers, especially outside of large, high cost of living metropolitan areas. And so a group of businesses and industry groups got together, and some of them had mini actions all over the country during this time, but the main ones that really put a stop to it were this particular case that Sarah's going to go into in a little more detail.
Yes, sure. So, so the Obama, like Rebecca said, the Obama administration, President Obama issued a memorandum to his Secretary of Labor, Tom Perez, said, I want you to change these rules, and the primary purpose was to bring them kind of up to current day pay. And so issued new rules, and pretty immediately there was a lot of challenges. And as Rebecca said, it was, you know, kind of all over the place, but there was one large group in the Eastern District of Texas that sued, and it was something like 19 states, along with the U.S. Chamber of Commerce and several related industry groups who bound together and sued the Department of Labor in the Eastern District of Texas. And they requested a couple types of relief, but primarily they requested declaratory relief that this new rule was not valid. And so first they wanted declaratory and injunction relief, halting the implementation of the new rule. As Rebecca said, the new rule was set to go into place in December of 2016, so they said, whoa, we want to stop, immediately please halt this rule while this litigation is pending. And then they moved for summary judgment on their claim that the new rule was invalid. The Eastern District of Texas largely agreed. In November of 2016, it granted the injunction, and a few other things, as you all know, happened in November of 2016. Namely, President Trump was elected as well. And so the injunction blocked the new overtime regulation from going into effect effectively and through to the end of the Obama administration. And then litigation continued, notwithstanding the fact that President Trump was inaugurated. However, the Eastern District of Texas granted the plaintiffs another victory in August of 2017 and said, so just this past August, and said summary judgment in the plaintiff's favor is granted. This new rule is struck down as generally an excessive exercise of the DOL's delegated authority. What that means is the DOL has to get its instructions from the executive, and the executive, in acting through its executive authority, must derive the directions that it wants the DOL to move from legislation. So President Obama, acting at least ostensibly under the authority granted to him by the legislature in creating the DOL and the FLSA, said, I want you to create these new rules. The challenge was that you're actually going outside of what the authority the legislature has delegated to you and the Eastern District of Texas agreed. And there's no real indication that the Trump administration is gonna obviously go back to what the Obama administration was doing. And so that's basically the status quo of the overtime rules.
Yeah. And it was an interesting decision for those of us who geek out on this law, because it really was just attacking the new regulations were just raising the dollar threshold, and that dollar threshold is in the first set of regulations that came out in after the 1938 law was passed. So it was kind of a curious thing to all of us. You know, we all represent employers, and we didn't want the threshold to go up that high either, but we thought it was an interesting strategic decision to attack the dollar amount, because that seemed pretty clear that you could index that to the cost of living. Yes.
Rebecca, I'm sure there was no strategy decision in selecting the Eastern District.
Right.
Right. That was obviously a sympathetic court. It was a classic forum shopping area, and they knew that concepts like excessive authority from the administrative procedures perspective would be heard. And certainly if somebody had tried to litigate the 2004 changes, which really were much more discretionary because they were changing the duties, I think everybody would have thought, oh, that's a great case, and we all would have jumped on it. So the sort of underlying argument was not great, but they had a really sympathetic court to hear that. And I should be repeating that. Did everybody hear that Jocelyn was asking basically about the strategies to select this in the Eastern District of Texas? And yes, that's exactly what they did. So what we have is the old rules, which are what I started with. And I should say that we almost never get any kind of complaints about the actual dollar amount, right? You either pay $23,000 and change or you don't. Where the play is on the salary test is that other area. Are you really paying on a salary basis? What are you deducting? You know, are you following those 7 exceptions if you're reducing the person's pay? And so that didn't have any language in the proposed rules under President Obama, and there's no indication that that concept is going to get any clearer for employers. So I encourage you to just learn what those 7 exceptions are and use somebody who is exempt, who is not coming to work. The solution is discipline. It's not deduction in pay, because you don't want to lose your exempt status by treating them like an hourly person, and that's our general tip in that regard. And we don't see any, I forget what your next slide is, but we don't see any idea that President Trump is going to have Acosta look at this issue. They've got other issues that they're addressing.
Yep. So one of the other issues that has gotten a lot of play in the media in the last year has been prevailing wages. So just to give a brief background, there's a number of relevant statutes that play into prevailing wages as they affect the construction industry. And but typically it's just referred to as the Davis-Bacon related acts. Here are some of the related acts, but what they essentially do is establish the wages that should be paid to particular trades in a particular locality. So they are a little bit jurisdiction driven. So they require a minimum prevailing wage, which is not the same as the minimum wage, obviously, for laborers and mechanics on federal and federally assisted construction projects in excess of $2,000. So obviously not hard to meet that. For construction, alteration, or repair of public buildings or public works, contractors and subcontractors have to pay their laborers and mechanics no less than the local prevailing wage and fringe benefits. It directs the Department of Labor to determine the local prevailing wages. Many of you have probably heard of Little Davis-Bacon Acts. What that refers to is a state can enact. So the federal law is sort of the floor. A state can enact another law that sets other prevailing wages for the state for state-funded projects. So there's a lot of debate over what the industry impact of prevailing wages is. A lot of particularly smaller businesses argue that Davis-Bacon prevailing wages are oppressive and cost them a lot of money. So there's a lot of talk in Congress about changing the prevailing wages, withdrawing them altogether, or lowering them, or doing something to alleviate some of the pressure on employers. So one example of this is there was a hearing last March, and the chairman of the National Association of Home Builders, at the time he was the first vice chairman, now he's the chairman, Granger McDonald, testified before the Senate Finance Committee. And I should say that this is Davis-Bacon and the related acts is always a hot topic in Congress. So every so often you see a Senate hearing and consideration of whether or not these rules should be changed. And so he testified, and I'm not going to read the whole thing out loud, but he testified that the law's original intent actually is frustrated because it creates a burden on the employer, and it hurts them in competitive bidding. He went on to say he has lost business to a lot of subcontractors due to constraints over Davis-Bacon, and including subcontractors he had worked with for decades. He said that they reduced the supply of subcontractors, and all in all, he basically implored the Senate to withdraw Davis-Bacon or amend it. The Trump administration kind of dangled potential change out in the open for some time, particularly early on in the Trump administration. In late 2016 and 2017, there were a lot of rumblings in the media that the Trump administration was considering doing something about Davis-Bacon, including repealing or suspending the Davis-Bacon related acts. And in a New York Times interview, President Trump responded to a Davis-Bacon question. He was a little cagey, which is not unusual for him, but they basically, the last question he was asked during this interview was, are you going to do something about Davis-Bacon? And he said, well, we're going to make an announcement, and you better be ready for it. It's coming in 2 weeks. He gave that date, and he said, on Davis-Bacon, and then the New York Times pushed him for more information, which he wouldn't give. And it was, of course, reported across media in the New York Times. 2 weeks later, nothing happened. And President Trump did meet with a lot of union leaders around the same time, and there's some indication that his mind was changed on by meeting with the union leaders. So there was no announcement, and then in conservative media, obviously, they report that the DBRA is very protectionist, and that President Trump is going to be forced to make a move on Davis-Bacon. But nothing has changed thus far, and in fact, in President Trump's 2018 infrastructure plan, which he unveiled on February 11th, 53-page plan worth $1.5 trillion potentially, depending on how you calculate that. It basically, the infrastructure plan maintained the prevailing wages, thereby indicating that President Trump's mind had in fact been changed, potentially by these union leaders, potentially by somebody else, but at least it could have been a simple throw to Davis-Bacon proponents, because the plan overall includes a lot of spending. And in any event, he gave no indication that he was going to engage on that issue, and the Department of Labor hasn't given any indication that it is going to suspend or withdraw Davis-Bacon anytime soon.
So just a word on all of those related acts, and then also on the kind of pickle that you can get in with how they interact. So in addition to the Davis-Bacon, which is probably the one that you all are primarily concerned with, the McNamara-O'Hara, which is the Service Contract Act, my experience is a lot of employers don't know that they are also subject to that as well. For example, I was working with someone in our Alaska office yesterday, and they clearly knew they had to comply with Davis-Bacon because it was a construction project, but they had some service people, namely cooks and janitors, who were also on the project, and of course, you can't find them anywhere in that list, and of course, the analysis that we concluded was they're probably subject to the Service Contract Act because it is a federally funded project, and these folks are providing services to that project, and so there's a whole scheme under that group. And then the other kind of sticky wicket that goes with this, of course, is the Buy American, Hire American Executive Order, which requires you to consider first U.S. workers, and it has an implication on the immigration scheme, and the immigration scheme uses the prevailing wages that are set forth in Davis-Bacon and the Service Contract Act as a baseline to make sure that you are not disadvantaging U.S. workers if you are hiring non-immigrant foreign nationals into non-immigrant temporary visas. And so my guess is when he met with the union folks and met with some of the people, he saw how this is really connected to a larger scheme, and it wasn't just as easy to throw it away.
Not to mention that because several states have their own little Davis-Bacon, I mean, obviously that's for state-funded projects primarily, but there can be overlap and complications with the just variety of jurisdictional polls for contractors.
So, sorry to take you
No, that was great. Okay, so we're going to talk about regulatory current events now, which is really just an extension of what the things that we've already been discussing and kind of what's been reported maybe more in the media, but maybe just in our trade magazines.
So I think the biggest news is President Trump's announcement that, and the folks within his administration saying that they wanted to merge the OFCCP and the EEOC. So of course, the OFCCP is the Office of Federal Contract Compliance Program. And that always bothers me that it's an office of a program, but, so I'll get over that eventually in my career, or else I'll retire. It's a division of the Department of Labor, and it is responsible for ensuring that federal contractors, regardless of which agency the federal contract comes in, could come from the Department of Defense, could come from the Department of Education, but the OFCCP is going to make sure that the federal contractor is adhering to the regulations and executive orders and the actual terms of the contract, with the exception of FAR, right? That's going to be done in another form. They're going to deal with all of that. The main thing that they do, of course, that we think about, the OFCCP that is that they conduct audits of the affirmative action programs that are generally required of federal contractors under the executive order and then the other anti-discrimination laws. So that's their primary mechanism for making sure that federal contractors are complying with the myriad of executive orders and regulations related to federal contracting. EEOC, Equal Employment Opportunity Commission, its primary responsibility is to enforce the anti-discrimination laws, mostly Title VII, but there are, of course, other ones like the Americans with Disabilities Act. They also take jurisdiction over the Age Discrimination and Employment Act, despite that being technically an amendment to the Fair Labor Standards Act. If you're not a government wonk, it makes sense that these two groups are doing the same thing, but of course they're not. There are very subtle differences with regard to the anti-discrimination components that are contained in most of the affirmative action and other anti-discrimination legislation and regulation, and Title VII and those laws are statutorily driven and then interpreted via the courts, and then the EEOC offers guidance and things like that. So I think in President Trump's desire to have less government and to try to get some efficiencies, he thought they're both enforcing anti-discrimination rules, let's merge them. So the budget statement sort of tasked the two agencies to look to each other to say, how can we coordinate this? How can we work collaboratively? We want to make sure that by the end of fiscal year 2018, which is coming up, we can actually reduce redundancies and get some efficiencies, and that's just what that quote says. Tom Dowd issued a letter, and that's it in case you care, but I think you have an excerpt, don't you? Yeah. So basically, he wanted to consolidate and noted that if you did consolidate that, you were going to have to amend the statutes because you'd have to take the authority for two of these statutes away from the Department of Labor. Now remember, we said the OFCCP is under the Department of Labor. The EEOC is its own. So the Department of Labor, cabinet level position, EEOC, separate independent agent with 5 commissioners. And so doing that makes those of us who practice administrative procedures law just be like, wow, you just can't do that. And that's kind of what his letter points out there. So I think they thought that they needed to rethink this, and so right now we don't have any kind of intelligence. Those people that we talked to who claim to know more are pretty sure that the merger's not going to go anywhere, and they're going to leave the OFCCP where it is under the Department of Labor, which makes sense. What's interesting is I was just on a webinar yesterday with OFCCP issues, and they're really focused on finishing their audits. They're backlogged, of course, and so they have all these scheduling audit letters that have gone out, and they're trying to hurry up and get those done because they've just issued a new set in March, and they're beginning a new audit cycle. So they're really not focused on finding efficiencies and figuring out what to merge. They're trying to finish the outstanding audits that have a statute of limitations deadline looming. The good news for everybody in this room is that the most recent scheduling letters that were issued in March are not targeting the construction industry. So they've got some targets. They're targeting employers with more than 70 employees in an establishment, so that's good news too for smaller and mid-sized employers, but they are not targeting the construction industry, so that's good. And we're just not hearing anything about, other than other political commentary on this merger, so it's probably very unlikely. The other thing we're not hearing much about before you go into the rest,
Oh, sorry.
no, you can leave that up, is President Obama issued a whole bunch of other executive orders that affected federal contractors during his final years in office because he couldn't get legislation to get passed with regard to that. So he issued, as you all know, the sick leave requirement for federal contractors. He added transgender and sexual orientation to the anti-discrimination scheme under the executive order vis-a-vis your anti-discrimination policies. He issued a pay disclosure rule. We've seen nothing about that getting rolled back under the current administration. So we have to assume those executive orders are still in place, and if you're a federal contractor, you need to comply with all of those EOs that were issued under the final years of President Obama's administration. Okay, I'll go back on script now.
So another development, or maybe not so much a development, but a change with respect to the Trump administration in comparison with the Obama administration is a renewed focus on regulatory rollback. So the idea there is we as Republicans believe less regulation is better. It takes pressure off of business, and that's going to be a focus of our administration. And I should note that as soon as President Trump was inaugurated, he issued a regulatory moratorium, effectively that stayed the implementation of any kind of pending new regulations or the creation of new regulations. And
It was I forget what the title was, but if you were going to pass a new regulation, you had to get rid of two. So it was like,
And
for every one you pass, you got to get rid of two.
And he did so through executive order, if I remember correctly, which is not at all uncommon. In fact, President Obama did the same thing when he came into office, and President Bush did the same thing. And almost every governor who is a newly elected governor now engages in this type of regulatory moratorium as soon as they come into office, and then they slowly move back into either new regulations, or if you're like President Trump, trying to kind of consolidate and amend what's there, or repeal. And actually, that's one of the things that now I'm going to talk about. So last July, President Trump, through his White House Office of Information and Regulatory Affairs head Naomi Rao, announced that he was going to begin engaging in aggressive regulatory rollback. Ms. Rao said, there's a substantial withdrawal and rollback of proposed regulatory actions. It is also important to note that what we are doing now is in some ways fulfilling a number of longstanding principles that other presidents have talked about. So President Trump is not alone, and even President Obama and President Clinton, most modern presidents agree that the regulatory scheme in the United States has become somewhat unwieldy. It is difficult to navigate, and obviously extremely difficult for a small business or even any size business to understand without using lawyers and advisors to help them navigate. And so Ms. Rao was probably right that President Trump is trying to implement some principles that have existed for a long time, and not just in the Trump administration. One of the first ways that they've done this, and it was widely reported in the media, is by scaling back environmental regulations. So President Trump's administration, when I say President Trump, usually what I mean is his administration, because the fact of the matter is the president has so many things going on that usually he relies on people like Naomi Rao to implement his desires. And so his administration has sought the reversal of more than 60 environmental rules. Obviously, Scott Pruitt, the head of the EPA, is one of the people who is involved in this. And those that affect the construction industry include overturning flood building standards for federal infrastructure projects. It required federal agencies to protect new infrastructure projects by building to higher flood standards, but the Trump administration has scaled that back. And his administration has also delayed compliance dates for federal building efficiency standards. So Many of you are probably familiar with new building standards that require things like using LED lights and building to environmental and electrical efficiency. The Trump administration has issued delays on those regulations. The rules previously set efficiency standards, like I said, for design and construction of new federal buildings. Trump delayed the compliance to September 30th of last year, but it is unclear, if not doubtful, that those rules actually went into effect beginning September 30th. It appears that they're kind of being kicked down the road again. The Trump administration has reviewed and is considering revoking permitting programs for certain power plants. This was announced by Secretary Scott Pruitt, who established a panel to reconsider the permitting process for new facilities that might pollute the air. So obviously, power plant facilities that are likely to pollute go through stringent regulatory analysis and permitting requirements. It's looking like that's going to be scaled back somewhat. And there's also a new initiative that Rebecca's going to discuss.
Yeah, so something interesting that the Secretary Costa of the Department of Labor has launched is a self-reporting initiative. And so he's implemented a 6-month trial program for this particular self-reporting initiative. And it basically is allowing employers who are not currently under investigation for wage violations to report those to the Department of Labor, and then you would be assigned a representative from the Department of Labor, and they would work with you in a compliance manner to help figure out what it is that why you think you're out of compliance and what you can do to get back in compliance. And this is interesting because on the heels of that, they've also re-implemented the wage and hour opinion letters, which despite our consistent and effective arguments that they're not the law, they are still useful in guidance and in our counseling practice. And so it's nice to have those come back. And I imagine that was not an accident. I imagine that they felt like if they were going to have this self-reporting initiative, it was important to have compliance letters as well. And so the idea is, let's bypass litigation and come forward. California's OSHA has had this kind of program for decades where you can go to the compliance consultation side of the Cal OSHA agency and say, help us improve our safety, and then you kind of get a pass for about a year after you're done working with them, and they won't inspect you. So not sure what the results of this are going to be in terms of when and if they implement random audits, but at least for the 6-month trial program, and if they follow what President George W. Bush had put in place, you will basically get to work in a way that gets the workers their back wages, but puts you out of the risk for penalties being imposed by the Department of Labor for correcting this. And so that's, I have no idea what's going to happen with this. You always owe the employees wages no matter what forum the wage and hour complaint comes in. And so if it's a Department of Labor audit, or if it starts as litigation, you're never going to get out of paying the employee what they owed. But the penalties and the attorney's fees and all the rest of that is quite expensive. The actual unpaid overtime is usually not very expensive on an individual basis, and even sometimes on a company-wide basis, depending on how frequent overtime is. And so I think this is an interesting program to help address what has become the hot litigation area in the employment world. So it remains to be seen. And they were noting that they have recovered, over $1 billion in back wages over the past years. And so the idea is, let's clean up the court system. It kind of puts a kibosh on the plaintiff's bar, because that's kind of been seen as their ability to get attorney's fees, and this has been their new cash cow from a litigation perspective. So it's an interesting approach in that regard too. So we can help you if you're actually interested in taking advantage of the program. I think you heard from Ryan Mick this morning, and he's one of our wage and hour experts here in Minnesota. We have them in other offices as well. And so if you think you might have had a problem and you're interested in figuring this out before you just sign up for their program, come talk to us and we can talk about whether it makes sense to do that. I should make a note on this too. One of the other reasons why we think it's interesting is it's often hard when you discover your own wage and hour issues to clean them up, because you're sort of shining a light on, we haven't been paying you overtime, and how far back do you go when you fix that issue. And so this could be a useful tool in that regard, but we don't know yet.
With that, we'll take any questions that you have about any of the material we've just presented, or anything else that might be on your mind in terms of regulations.
Crystal clear, all righty.
Thank you, Sarah and Rebecca. We're going to take a short break. And then come back for our final panel. And again, Cornell, I'm putting a lot on your shoulders to make this entertaining and worthwhile, so. It's on you, buddy.